What happened when women hundreds of years ago didn't want to continue their pregnancy, and how did we get to where we are today? Keep watching for the complete history of Roe v. Wade. During the American colonial period, colonies followed British common law when it came to abortion. This meant that abortion was loosely regulated, but only after the quickening. The idea of the quickening, or the point when a pregnant person can feel the movements of the fetus, can be traced back to Aristotle and was considered to be the developmental stage that separated the embryo from the fetus. In colonial America, there's reportedly only one documented case of a surgical abortion, according to Women in Early America by Dorothy A. Mays. In 1742, Sarah Grosvenor tried to induce an abortion several times by ingesting herbs. When they didn't work, she went to a physician who tried to induce a surgical abortion, but unfortunately, Sarah died as a result. After her death, both the doctor and her lover were tried for her death, but they were both acquitted. In The Changing Voice of the Anti-Abortion Movement, authors Paul Surratt and Kelly Gordon write that after independence, American states ended up basing many of their laws on British common law, which was difficult to implement and rarely enforced. In addition, because procedures related to reproductive health were rarely discussed and left up to midwives and medical practitioners, drugs that could induce abortion were widely available. During the period of enslavement in the United States, Black people used a variety of methods to maintain reproductive agency or keep their children from being enslaved, ranging from avoiding sexual contact, inducing abortions, and infanticide. Across cotton plantations, some enslaved people chewed cotton roots to prevent pregnancy or induce an abortion. Others used turpentine, which would cause a miscarriage. According to the PSU McNair Research Journal, these reproductive choices would have been considered resistance to slavery, because any successful attempt to limit reproduction resulted in a, quote, loss of capital for slaveholders. But as Black Perspectives notes, there are unfortunately few records of the views of enslaved people regarding abortions. This is due to the fact that Black people would have to recount their experiences of slavery to interviewers and editors who were white men, which limited what they could say openly about their methods of contraception. The very first state to pass legislation that explicitly outlawed abortion after the quickening was Connecticut in 1821, making a direct reference to a person being, quote, quick with child. Other states followed suit, but as The Changing Voice of the Anti-Abortion Movement notes, many of these early laws didn't punish the person who had the abortion, and instead targeted the apothecaries that sold abortifacients. But despite these laws, marriage manuals published through the 1830s continued to offer tips on abortions. The Duke Law Journal writes that almost 25 years later, in 1845, New York State passed one of the first laws that actually criminalized the person having the abortion. The law stated that those who took an abortifacient or underwent a surgical abortion before the quickening were guilty of a misdemeanor, while those who induced an abortion after the quickening were guilty of a felony. Before long, 14 other states had also adopted similar abortion laws. Despite the anti-abortion laws enacted in the United States, abortion remained relatively common practice in the 19th century. According to Abortion in America by James C. Moore, in the 1850s, it was estimated that 1 in every 5 pregnancies resulted in an abortion.
Would have to be soon. While the fetus is still small.
Other estimates indicated that roughly 2 million abortions were performed in the United States every year. And even with the increasingly common anti-abortion laws, few doctors or midwives were ever arrested or convicted unless the person who had the abortion died, according to The Atlantic. There were many abortion providers in the United States, but the most famous of them was Anne Thrau, also known as Madame Restel. The Embryo Project Encyclopedia writes that Restel would provide herbal treatments by mail to induce abortions. Restel charged financially insecure people $20 for an abortion, while wealthy women were charged $100. This amounts to roughly $660 to $3,300 in 2022, and it's not unlike the cost of abortions in the 21st century. Restel reportedly provided abortions for up to 35 years, with offices in New York, Boston, and Philadelphia. In addition to providing abortion services, Restel also provided aid to people who wanted to carry the pregnancy to term. She offered a boarding house where people could give birth, and afterwards would facilitate the adoption for an additional fee. One of the strongest opponents to abortion to come out during the mid-19th century was the American Medical Association. The AMA was formed in 1847 by wealthy doctors who wanted to monopolize the market and legitimize only their method of practicing medicine. Physicians claimed that they were the ones with expertise and sought to move abortion into entirely their own purview. And the medical community wasn't the only voice in the anti-abortion movement. Racists and eugenicists also challenged people's reproductive agency, claiming that the influx of non-white immigrants would soon outnumber white Americans, and arguing that access to contraceptives and abortion threatened white Protestants who wanted to maintain control over American society. Following the assault by physicians and racists, Congress passed the Comstock Act of 1873, named after Anthony Comstock, the head of the Society for the Suppression of Vice. PBS writes that the Comstock Act defined contraceptives and abortifacients as obscene, and it was a federal offense to send anything that could be considered obscene, indecent, or immoral through the mail. The punishment included imprisonment between 6 months and 5 years, or a fine between $100 and $2,000. This was reportedly the first law of its kind in the Western world, and after the federal law was passed, 24 states followed suit and enacted state legislation as well to restrict the trade of contraceptives and abortifacients. According to the Embryo Project Encyclopedia, the Comstock Act was enforced until it was overturned by the decision in Griswold v. Connecticut in 1965, which held that it was unconstitutional to restrict access to birth control. But by the beginning of the 20th century, every state in the United States had outlawed abortion, though there were some differences between the states as to what exactly was prohibited, such as exceptions if the life of the pregnant person was at risk, among other things.
You what? With child?
With the rise in anti-abortion laws and messaging, people didn't stop seeking out abortions, but their illegality made it much more difficult to procure safe abortions, and as a result, maternal mortality rates rose. The American Journal of Clinical Nutrition writes that although there's little reliable data about pregnancy-related deaths in the United States before 1915, afterward, the United States had the highest maternal mortality rates of any developed country. In Lessons from Before Roe, Rachel Benson Gold writes that in 1930, abortion was listed as the official cause of death for over 2,500 people, roughly 18% of pregnancy-related deaths that year. And according to the 1976 congressional hearings on abortion, in the 1960s, between 40 and 50% of pregnancy-related deaths in states like New York, Pennsylvania, and Michigan were due to abortions that people had sought, despite them being illegal. The official death toll declined over the decades, likely due to the introduction of antibiotics, but even in 1965, abortions accounted for 17% of pregnancy-related deaths.
I thought you said he was at Real MD.
The guy had a dirty knife and a folding table.
On March 13, 1970, Hawaii became the first American state to legalize abortion, allowing it to be performed if requested by a pregnant person as long as it was performed in a hospital by a licensed doctor before 24 weeks. However, according to the University of Hawaii, it was also required that a person be a resident of the state for at least 90 days. Up until then, abortion was only allowed in Hawaii if it was necessary to save the life of the pregnant person. According to the 1976 congressional hearings on abortion, there were over 3,500 abortions performed in Hawaii in the first year after legalization. There is evidence that the demand existed before it was legalized. In April 1970, New York also voted to legalize abortion, allowing them to be performed up through the first 24 weeks of pregnancy. 3 years after states began legalizing abortions, the United States Supreme Court ruled on 2 landmark cases that effectively decriminalized abortion on a federal level. The first of these cases is the well-known Roe v. Wade, which struck down the anti-abortion law in Texas on January 22, 1973. According to the Liberty University Law Review, with Roe v. Wade, the Supreme Court ruled that anyone could terminate their pregnancy during the first 6 months of pregnancy for any reason.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions.
The second case is Doe v. Bolton, which overturned the abortion law in Georgia, and whose decision was also released on January 22nd. The Doe v. Bolton ruling upheld the reasoning used in Roe v. Wade and added to it, finding that the requirement for hospital accreditation unfairly restricted access to abortions. In addition, the residency requirement was also ruled to be unconstitutional. The New Mexico Law Review writes that the Supreme Court used the trimester framework in their decision. During the first trimester of pregnancy, the state was considered to have no authority to regulate abortions. During the second trimester, the state could regulate the procedure as long as the regulation was related to the health of the mother, and only in the third trimester did the state have justification for regulation for the purpose of protecting the fetus. After abortion was legalized in the United States through Roe v. Wade in 1973, there was a violent backlash. Anti-abortion terrorists proceeded to target places that offered abortions, resulting in thousands of violent incidents. According to the National Abortion Federation, between 1977 and 2014, anti-abortion terrorists committed at least 8 murders, 17 attempted murders, 42 bombings, 100 acid attacks, 182 arson attacks, 663 anthrax or bioterrorism threats, and 4 kidnappings. In 1996, anti-abortion terrorist Eric Rudolph made headlines after he bombed the Centennial Olympic Park in Atlanta, Georgia on July 27th during the 1996 Summer Olympics. The shrapnel from the bombing killed Alice Hawthorne and injured 111 other people, Atlanta Magazine reports.
I don't know the magnitude of the device, but it went off with a bang.
In addition to bombing the 1996 Summer Olympics, Rudolph also bombed 2 clinics that provided abortions, one of them in Birmingham, Georgia, as well as an Atlanta bar. After he was arrested, Rudolph pled guilty to the bombings and released an 11-page statement in which he cited abortion, gay rights, and the federal government as the motive for his attacks. In his statement, he claimed, "Abortion is murder, and when the regime in Washington legalized, sanctioned, and legitimized this practice, they forfeited their legitimacy and moral authority to govern." Less than 20 years after adopting the trimester framework, the Supreme Court ended up rejecting the framework in Casey v. Planned Parenthood. According to the University of Baltimore Law Forum, in Casey v. Planned Parenthood, the Supreme Court held that the state is within their rights to try to persuade people to choose childbirth over abortions. After the increase in abortion restrictions, people didn't stop getting abortions. Instead, states started prosecuting people for miscarriages and stillbirths, since it's almost impossible to tell the difference between an abortion and a miscarriage, also known as spontaneous abortion. One such case was a conviction of Brittany Poolaw, a member of the Comanche Nation, who was convicted in 2021 of second-degree manslaughter for a miscarriage and was sentenced to 4 years in prison, NBC reports.
There are at least 3 cases in Oklahoma out of a single county prosecuting pregnant women for their pregnancy loss.
In 2019, Marsha Jones, a black woman in Alabama, was also charged with manslaughter after being shot in the stomach while pregnant. According to the New York Times, the police allege that she started the fight that led to the shooting, which they said made her responsible for her miscarriage. Meanwhile, no charges were filed against the person who actually fired the gun. The manslaughter charge against Jones was eventually dropped. On June 24, 2022, the Supreme Court handed down its decision on Dobbs v. Jackson Women's Health. In a 6-3 vote along ideological lines, the court overturned both Roe v. Wade and Planned Parenthood v. Casey, meaning that there was no longer a federal protection of the right to end a pregnancy in the United States. Justice Samuel A. Alito Jr. wrote for the majority, "Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives." However, CNN reports that the pro-choice movement was given a poignant note in the dissent from the 3 liberal justices, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, who closed out their dissent by writing, "With sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection, we dissent."